Linda spent 38 years as a registered nurse in Cleveland, Ohio. She worked night shifts at the same hospital for 3 decades. She raised 2 children alone after her husband passed in 2008. She was careful with money. She had a 401k, a small hospital pension, and Social Security on the way. When she retired at 64, her HR department gave her a folder of paperwork. She filed what they marked as urgent. She set the rest aside, meaning to come back to it later. 3 months after her last day of work, 4 things went wrong. Her first pension check arrived with the wrong amount of federal tax withheld. Her Social Security started, and there was no withholding at all. The COBRA election letter from her hospital had quietly expired in a drawer, and her 401k beneficiary form still listed the husband who had died 17 years earlier. Linda had filed everything HR marked as urgent. Nobody had told her the 5 documents that mattered most were not in that folder. I'm going to walk you through every one of those 5 documents, exactly what they are, exactly when to file them, and exactly what happens if you do not. Most retirees miss at least one of these. Linda missed all 5. Fixing it after the fact cost her about $1,800 in CPA and advisor fees, and 6 months of stress she did not need. Filing them in advance before her last day of work would have cost her nothing. This is for informational purposes only and not financial, tax, or legal advice. Please consult a qualified tax professional, financial advisor, or attorney for your specific situation. My name is Robert. Pause 20S, your guide to the retirement paperwork your HR department probably did not mention. If this is helpful, hit subscribe. I cover the documents, deadlines, and quiet rules of retirement that most retirees only learn about after a bill arrives. Today, I am going to walk you through the 2 tax forms that decide how much money the IRS takes from your pension and your Social Security every single month. I am going to explain the 2 enrollment forms with hard deadlines that close fast and what happens to the people who miss them. And I am going to show you the 1 document most retirees update once when they got married decades ago and never touch again, even though it overrides their will. 5 documents, 3 categories. Everyone has a deadline. By the end of this video, you will know all 5 by name. Document number 1, Form W-4P. Form W-4P is the withholding certificate for periodic pension or annuity payments. It tells your pension administrator or your IRA custodian if you elect how much federal income tax to withhold from your monthly distributions. Here's what most retirees do not realize. If you do not file Form W-4P with your pension provider, they do not skip withholding. They use a default. The default has changed over the years under the Post 2022 W-4P rules. Payers without a recipient form on file generally withhold, as if the recipient is a single filer with no adjustments. That can be substantially more or substantially less than what you actually owe based on your real situation. Linda's hospital pension was about $3,200 a month. Without a W-4P on file, the default withholding tables took an amount that did not match her real tax bracket. Some months it was too much. After her Social Security started and her income picture changed, the default withheld too little. She did not realize it until tax filing when she owed a balance she had not budgeted for. The fix is filing Form W-4P with your pension administrator before your first check and reviewing it anytime your other income changes. A tax professional can help you set the right amount based on your actual situation, your pension, your Social Security, any IRA distributions, and your standard deduction. The form is short. It exists for exactly this reason. Most retirees never see it because their HR department hands over the pension forms and not the tax form. Document number 2, Form W-4V. Form W-4V is the voluntary withholding request used for federal income tax withholding from government payments, most importantly, your Social Security benefit. Here is the rule that surprises every retiree who does not know about it. Social Security does not automatically withhold federal income tax from your monthly benefit. Unless you file Form W-45, every dollar arrives gross, no federal taxes taken out. You then face the entire tax bill at filing time the following April. For some retirees, that is fine. They calculate their tax in advance and pay quarterly estimated taxes throughout the year. For most retirees, it is a problem. They get the full Social Security check, spend like that as their net income, and discover at tax time that they owe thousands. There is a second consequence. Under Internal Revenue Code Section 6654, if you do not pay enough tax through withholding or quarterly estimates throughout the year, You can owe an underpayment penalty on top of the tax itself. There are safe harbor rules, but many retirees fall through them. Form W-4V gives you 4 withholding options. You can elect 7%, 10%, 12%, or 22% of your monthly Social Security benefit to be withheld for federal taxes. Those are the only 4 options on the form. You file it with the Social Security Administration, and they apply it to your check going forward. Linda's Social Security started at about $2,200 a month. Without W-4V, no federal tax came out. By the time her tax preparer ran the numbers in April, she owed federal income tax on her pension, plus her Social Security, plus her IRA, and she had paid none of it through withholding. She was lucky to fit into a safe harbor and avoid a penalty. Most retirees are not that lucky. The fix is filing Form W-4V with the Social Security Administration before your first check, or at the latest within the first few months. The right percentage depends on your overall tax picture. A CPA or tax professional can model it. Document number 3. Forms CMS 40B and CMS L564. The third document is Medicare. The form is CMS 40B, Application for Enrollment in Medicare Part B. If you delayed Part B because you had active employer coverage, you also need CMS L564, which is the request for employment information. Your former employer fills it out to confirm your coverage timeline. This is the deadline most people are at least vaguely aware of, but the rules are tighter than they realize. Your initial enrollment period is exactly 7 months. It opens 3 months before your 65th birthday month, includes your birth month, and closes 3 months after your birth month. If you miss your initial enrollment period and you do not qualify for a special enrollment period, which you only qualify for if you had active employer coverage that ended, you wait for the general enrollment period. And you face the late enrollment penalty, 10% of the standard Part B premium for every 12-month period you were eligible but not enrolled, permanently, for the rest of your life. CMS 40B is straightforward when filed on time. The form CMS L564 is what catches working retirees off guard. Many of them retire after 65 and forget that they needed their old employer to fill out a form to qualify for the special enrollment period. Without it, they cannot prove their delay was justified, and they fall under the late enrollment penalty rules. Linda was 64 when she retired. Her initial enrollment period would open 3 months before her 65th birthday, a few months after her last day of work. She had not yet thought about Medicare paperwork. She did not know about CMS L564. Fortunately, she enrolled inside her 7-month window, but it took her CPA pointing it out for her to act in time. The fix is putting CMS 40B on your calendar 3 months before your 65th birthday, not waiting for your hospital, your old employer, or Social Security to remind you. They generally will not. Even if you are not yet 65 at retirement, plan now. Document number 4, the COBRA Election Notice. Under the Consolidated Omnibus Budget Reconciliation Act of 1985, the law that goes by the unfortunate acronym COBRA, most workers who lose employer health coverage have the right to continue that coverage at full cost for a period of time. For most qualifying events, including retirement, the continuation period is up to 18 months. Here is the timing. Your former employer is required to notify you of your COBRA rights within 14 days of being notified of the qualifying event. That notice arrives by mail, usually within a few weeks of your last day. The clock starts. You then have 60 days to elect COBRA coverage. The 60 days runs from the later of 2 dates: the date the notice was provided, or the date your existing plan coverage actually ends. After 60 days, the option is gone. This is the document Linda set aside. Her hospital plan coverage ended on her retirement date. The notice arrived 10 days later. She read the first paragraph, saw the words "continuation of coverage," set it on her kitchen counter, and decided she would deal with it later. 2 months later, she found it again, and the election window had closed. She had options. Marketplace insurance under the Affordable Care Act has a special enrollment period, triggered by loss of employer coverage. She enrolled there instead, but she lost the option to stay on her hospital's plan that her doctors knew, with the prescription formulary she was used to. The fix is opening the COBRA election notice the day it arrives. Decide within the first 2 weeks whether to elect or not. If you choose not to elect, you still have the marketplace option, but only if you act within 60 days of losing coverage. Document number 5, updated beneficiary designations. This is the one most retirees never think about. It is your beneficiary designation on your retirement accounts, life insurance, pension, and any transfer on death or payable on death bank accounts. Here is the rule that matters. Your beneficiary designation overrides your will. In 2001, the Supreme Court of the United States ruled in Egelhoff v. Egelhoff that ERISA-governed retirement plan beneficiary designations preempt state probate law. What it means in plain English, if your 401k beneficiary form lists your ex-spouse inherits even if your will says everything goes to your children. The will cannot fix it after the fact. For qualified retirement plans like 401ks and pensions, ERISA Section 205 also requires spousal consent if you want to name anyone other than your current spouse as primary beneficiary. The consent has to be in writing and witnessed by a notary or plan representative. Linda's beneficiary designation on her 401k was a form she filled out in 1981 when she got married. Her husband died in 2008. She updated her will. She did not update the beneficiary form. For 17 years, her 401k, which had grown to about $320,000, was technically going to a deceased person. In her case, the contingent beneficiaries listed were her children, so they would have inherited regardless. But the paperwork would have been messy and slow, and many retirees in the same situation have no contingent beneficiary listed at all, which sends the account to probate. The fix is reviewing every beneficiary designation on every retirement account, every life insurance policy, every pension, and every bank account with a TOD or POD designation. Update them after any major life event: marriage, divorce, death of a spouse, birth of a child or grandchild. Update them when you retire. And keep copies of the updated forms. Linda is 65 now. Over 6 months, working with a CPA and a fee-only fiduciary advisor, she fixed every one of the 5. She filed Form W-4P with her pension administrator. Her withholding now matches her actual tax bracket. She filed Form W-45 with the Social Security Administration. Her benefit checks now have 12% withheld. She enrolled in Medicare Part B inside her initial enrollment period with CMS, 40B and CMS, L564, and avoided the late enrollment penalty. She missed COBRA but caught the Marketplace Special Enrollment Period for ACA coverage. And her beneficiary designation now lists her 2 adult children, Sarah and Mike, as primary, with her grandchildren as contingent. The whole cleanup cost her about $1,800 in professional fees, plus 6 months of stress. Filing all 5 before her retirement date when her HR department had access to her, when her pension administrator was already onboarding her, when her hospital health plan was already processing her separation, would have cost her nothing. Most of the forms could have been filed in a single afternoon. You are not Linda yet, or maybe you already are, and you have one of these to fix. But if you are within 1 or 2 years of retirement, the time to file these 5 is now, not after your last paycheck. Now. If this helped you, hit the like button. It takes 2 seconds and it helps more retirees find this information. Subscribe if you have not already. And if you know someone planning to retire in the next year, a spouse, a sibling, a friend, send them this video. Today, not tomorrow. Pause 24S. Today. Drop your situation in the comments below. Are you already retired and have one of these to fix? Or are you still working and want to know which one to tackle first? I read every single one, and the most common situations become future videos.